Michael, you're alleging that Michael Cohen has been attempting to intimidate Ms. Clifford into silence and shut her up. How has he attempted to do that?
Well, he's actually, Anderson, attempted to do that by means of a number of steps, including filing this bogus arbitration against her, communicating through her prior counsel, making threats to her relating to what may happen to her from a legal perspective in the event she does not deny allegations of the affair, etc.
How recent have these threats, in your words, been?
These threats continued until, in fact, only a few hours ago, when Mr. Rosen, Lawrence Rosen, the attorney who now purports to represent Mr. Cohen and the entity EC LLC, sent email correspondence to me threatening that if Ms. Daniels continues to talk, she may be subjected to significant additional damages.
I want to ask you about this arbitration. You say that back, I think it was February 27th, that Michael Cohen, quote, surreptitiously initiated a bogus arbitration proceeding against Ms. Clifford in Los Angeles. Can you describe what happened?
Well, our understanding, and quite honestly, we're still looking into this, Anderson, but our understanding is that Mr. Cohen, on behalf of the entity EC, went into ADR Services in Los Angeles, filed an arbitration proceeding, managed to get ADR Services to appoint an arbitrator immediately, then managed to get that arbitrator to issue a temporary restraining order against Ms. Daniels. He did so without any notice to Ms. Daniels, no prior notice to Ms. Daniels.
She didn't even know this was happening.
She had absolutely no idea, and that was by design of Mr. Cohen. She had no idea it was happening. No opportunity to respond, no opportunity to present her case, no opportunity to have a hearing prior to the issuance of the order. And quite honestly, the entire process is absolutely untoward and improper. And to make matters worse, EC, pursuant to the agreement, which of course we allege is invalid, EC, pursuant to that agreement, Section 5.1.1, doesn't even have the ability to go in and obtain such a restraining order. That would have to be accomplished by way of DD, otherwise known as President Trump. So EC didn't even have standing to pursue this, which is why we find the statement by Ms. Sanders, and I'm sure that Ms. Sanders was not told the truth before she stood at the podium today and made the representation that she did, but we find her statement that President Trump has already, quote, won, close quote, this arbitration to be absolutely bogus and baseless.
But if they were able to get a temporary restraining order, wouldn't that indicate that they had won that round of arbitration?
Well, who's they? I mean, according to Mr. Cohen, this was pursued on behalf of EC, not DD or President Trump. And if there's one thing we know of the last 4 to 6 weeks, it's that Mr. Cohen and others close to the Trump administration have made it clear that EC is not President Trump.
I mean, your client did agree to arbitration at the time she signed the agreement, didn't she?
She agreed to arbitration, but that agreement fell by the wayside when a party to that agreement, namely Mr. Trump at the time, did not sign it. That agreement is null and void. It doesn't mean anything.
Can you tell us about this arbitration? Can you tell us who appeared on Michael Cohen's behalf? You're saying nobody appeared on the president's behalf because this wasn't, technically, this was just the LLC running bringing up the arbitration?
That's correct. That's to the best of our knowledge. I mean, Anderson, at this point, you know about as much about this arbitration as we do. Because nobody bothered to tell us about it before it happened. Nobody bothered to invite my client to the party, if you will, which makes the issuance of this order even that much more curious, that it happened within a matter of hours, all in an effort, and I want to be really clear about this, all in an effort to keep this matter under wraps, keep it out of public view, hide the facts, and silence my client. There's a pattern in practice that has governed the way that my client has been dealt with by Mr. Cohen and President Trump for months. And that pattern in practice, Anderson, has continued up until even a few hours ago.
An attorney for Michael Cohen put out a statement a short while ago today saying, quote, the designated judge from the arbitration tribunal found that Ms. Clifford had violated the agreement and enjoined her from, among other things, filing this lawsuit. I mean, have you gotten a ruling? Have you seen this judge's ruling?
We've seen the temporary restraining order that was issued within hours of the filing. I don't know of any hearing that took place. I don't know of any findings that took place. And again, our position is we don't even belong in arbitration. This matter belongs in a court of law, a public court of law, a court of law owned by the people and open to the public. That's why we filed the matter in a court of law yesterday. We do not belong in arbitration, and we're not going to proceed in arbitration.
You're also alleging that Mr. Cohen forced Ms. Clifford to sign a false statement saying that reports of her relationship with Mr. Trump were false. How did he force her? I mean, do you have any evidence of that, documentation of any sort?
That there were significant threats made directed at Ms. Daniels, Ms. Clifford, that if she did not sign, that various things would happen to her. And I think when and if, legally speaking, correct. And I think when and if she provides a statement publicly about this entire matter, I think when the truth is known, the general public will likewise conclude that she felt like she had no choice but to go along with the demands of Attorney Cohen.
Does it put her credibility, though, in question in some people's eyes if just a few weeks ago she was saying, look, this never happened, and now she says it did?
Well, I think, of course, it puts her credibility at issue and raises questions about it. It'd be absurd for me to claim otherwise. But I think once she actually gives her statement and sits down for an interview, and hopefully she will have that opportunity, our position is that we want to give her an opportunity to make her statement, to tell about what happened, and then we're going to let the American public decide for their own, on their own, who's telling the truth and who's pulling the wool over their eyes. It's really that simple.
If the agreement is void, then why not just go ahead and violate it? I mean, you have nothing to worry about if it's not a real contract. Why bother going to court at all?
Well, in light of the constant threats by Mr. Cohen and others, my client is concerned and wants a court of law to adjudicate that, in fact, she is free from the agreement. I mean, we've already heard threats of $1 million per incident, per instance, where if my client were to come forward and talk about what happened and tell the truth about what happened. Regardless, by the way, they want to ding her for $1 million whether she tells the truth or doesn't tell the truth. Just the mere fact that she speaks, in their mind, entitles them to $1 million in each instance. That is one significant threat, to say the least. And by the way, we think that that's unconscionable and is another reason why the agreement would have to be thrown out. The mere suggestion of that is absurd.
The lawsuit claims, quote, it strains credibility to conclude that Mr. Cohen is acting on his own accord without the express approval and knowledge of his client, Mr. Trump. Are you referring specifically to the arbitration or to Cohen's alleged actions writ large?
Anderson, we're referring to it all. The suggestion that you would have an experienced, educated attorney like Mr. Cohen, who would run off half-cocked without any knowledge of his client, that he would negotiate and draft a detailed agreement that included his client as a party, that he would engage in weeks of negotiation, that he would reach agreement, that he would then send $130,000 in connection with that agreement, that he would then later institute an arbitration proceeding without knowledge of his client. All of this, to those of us that practice under the law as attorneys, it's ludicrous.
Wouldn't it be unethical?
Absolutely. We have an ethical obligation to inform our clients at all times of all material facts. It's one of the basic tenets of what we do. And the idea that somehow President Trump didn't know anything about this, and that Attorney Cohen was just running off and doing what he thought was best without any consultation with President Trump, it is patently absurd.
You do acknowledge, though, in your lawsuit, and I quote, the extent of Mr. Trump's involvement in these efforts is presently unknown. So you don't have actual evidence. This is just a supposition on your part based on, I mean, frankly, ethics and common sense.
Well, here's what I will say. We are not going to disclose at this point all of the facts and evidence that we have substantiating the allegations in the complaint, nor would we have set that all forward in the complaint. I mean, that just wouldn't be smart. But we certainly have more facts and evidence to support the allegation, or allegations, I should say, than what has already been disclosed. I mean, also keep in mind the timing of this. We're not talking about an agreement that was entered into at some point in time where nothing significant was transpiring in Mr. Trump's life. We're talking about an agreement that was being negotiated and entered into in the waning days of the 2016 presidential election, an election that at the time was very close, an election at the time where anything could happen and the slightest misstep could cause a candidate to lose the presidency of the United States. And yet Mr. Cohen expects the American people to believe that he was running off on his own and entering into this without any consultation with the candidate for the President of the United States, Mr. Trump. It's not believable. It doesn't make sense.
Do you view the money that Ms. Daniels received as a campaign contribution, regardless of who the money actually came from? Do you view it as a campaign contribution?
Anderson, we don't view it one way or the other. I think individuals that are far more qualified and educated on those laws and regulations are ultimately going to opine on that. Ultimately, if they conclude that in fact it was, Katie bar the door. I mean, I don't know where that ends, but if in fact that is the conclusion, I think that President Trump and the White House could certainly have significant problems. But again, that's not for us to opine on.
Is Katie bar the door a legal term?
No, it's a Southern term.
Can you explain just in non-legalese what Ms. Clifford wants? Because most viewers don't know what a declaratory judgment is. Does she want money? Does she want freedom to sell her story or tell her story to other media outlets? I mean, is that what this is about?
This is about freedom of speech at this point, Anderson. There's been a significant amount of misinformation that has been disseminated over the last 6 weeks. And remarkably, a lot of it has been at the hands of Attorney Cohen, Mr. Cohen. My client wants an opportunity to tell her story, to tell the truth about what happened and what didn't happen, to tell the truth about the events not only relating to her relationship with the president, but also the conduct and what she's witnessed over the last 12 to 18 months as it relates to efforts to silence her. She wants an opportunity to set the record straight. Ultimately, she wants the opportunity for the American people to pass judgment as to who's telling the truth. Is it her or is it Mr. Cohen? Is it her or is it President Trump? Is it her or is it Ms. Sanders? That's what my client wants, and that's what we're going to fight for.
Our chief legal analyst, Jeffrey Toobin, said that the contract to him reads like kind of a form that maybe has been used before. Does it seem that way to you? I mean, are you aware of any other women who signed similar contracts with President Trump?
Well, we're not aware of any other women, but let me just say this. In my experience, the way that this was handled and the documentation, quite honestly, this was amateur hour, Anderson. This is very, very sloppy. It's very, very messy. It is shocking, quite honestly, that something of this magnitude was handled in this way in the waning days of the 2016 presidential election.
What was so sloppy about it?
I have a lot of respect for Mr. Cohen. I think he's a good attorney in a lot of ways. I don't know the exact circumstances of what happened here, but this is not how something of this importance should have been handled, in my opinion.
And just to be clear, Ms. Clifford is not accusing President Trump of any sexual misconduct.
That is correct.
And in terms, I mean, just finally, where does this go from here procedurally? How long do the president's legal team have to respond? Do you have any sense of what the time frame is?
Well, the defendants in the case have approximately 30 days to respond in court. Hopefully we can expedite that. Hopefully they'll expedite it. There's no sense in dragging this out. Again, I think it's pretty simple. Did the president know about the negotiation, the terms, the payment of the money or not? Did he sign the agreement? I mean, this doesn't have to be a prolonged process. I mean, we should get right to it.